Council of Ministers.
Therefore, I am saying it is not, my lord, my submission that it is his.
Normally, the ordinance making power is of the executive.
I am not disputing that. Therefore, I said that that's not my submission. I preempted, my lord, that it has to be as per aid and advice. But there is a discretion even after aid and advice. That is what I want to show. Provided that the governor shall not, the constitutional prohibition, without instructions from the president, promulgate any such ordinance if, kindly come directly to B. Lord, so please read A first, Lord, so that it can be read in context. A bill containing same provisions would, under this constitution, have required the previous sanction of the president for introduction thereof into the legislature, like Article 30, 31, etc., etc., my lord. B is very relevant, my lords. He would have deemed it necessary to reserve a bill containing the same provisions for the consideration of the president. If it would have been a bill, he would have considered it necessary, despite aid and advice given to him by the Council of Ministers, that no, this needs reference to the president. I must refer it to the president for his assent. Now, please see, my lord, see, an act of legislature of a state containing the same provisions would, under this constitution, have been invalid unless, having been reserved for the consideration of the president, it had received the assent of the president. So, like Article 254, 254(2), the repugnancy. There is a repugnancy. So here, my lord, it makes it very clear that the framers of the constitution says that in the first part, yes, you will act as per aid and advice, as my lord, the Chief Justice very rightly pointed out, but he shall not do it if these three contingencies, and one of the contingencies be, he would have deemed it necessary. When the bill comes to him, he would have deemed it necessary to reserve the bill containing the same provision for consideration of the president. In that case, he needs prior instruction from the president in case of an ordinance. Now, please come to para 51. It may be pointed out that Article 213, page 767, para 41, 51. It may be pointed out that Article 213 is a power to promulgate ordinances. The ordinance is promulgated by the governor himself. Subclause B will have to be read in the context. In view of the nature of the ordinance itself and the fact that the governor is promulgating the ordinance, the question for the grant of assent, first option under Article 200, will not arise, because ordinance, there is no question of granting assent. He himself is promulgating the ordinance. Similarly, second option of withholding under Article 200 will also not arise. The assembly not being in session is the precondition for exercising the power of promulgation, and therefore option of returning would not arise. Thus, there is only one option for the governor out of the four options mentioned in Article 200, and that is referring the bill for the president's assent. Now, my lord, this provision came in for consideration before a 7-judge bench of this honorable court, my lord, which was not cited till date, my lord, because this Article 213 argument came, my lord, orally in the and in written submissions also in the reply. Therefore, I am, my lord, respectfully urging the counter. I'm not in rejoinder. This is how the central government interprets the constitution. Please come to, my lord, Krishna Kumar 768. In Krishna Kumar Singh versus State of Bihar, a 7-judge bench of this court held as under. My lord, then 231 is quoted. I'm skipping that. The first of the above condition arises in a situation such as the proviso to Article 304B of the Constitution. Under Article 304B, the legislature of a state is permitted to impose reasonable restrictions in the public interest on the freedom of trade, commerce, or intercourse with or within the state, notwithstanding anything in Article 301 or 303. The proviso requires the previous sanction of the president before a bill or amendment for the purpose of Clause B can be introduced in the state legislation. An illustration of second requirement, that is point 2 above, my lord, point 2 where B, my lord, is provided by Article 200 of the Constitution, under which the governor is required to reserve for consideration of the president any bill which, in his opinion, would, if it were to become a law, derogate from the powers of the High Court so as to endanger the position which it is designed to fulfill by the Constitution. Situations where the assent of the president is required, then point 3 above, are illustrated, my lord, 254, etc., my lord, where he will have to refer it to the president. There is a clear repugnancy, my lord. That's what the court said. Illustrated by Article 254, where a law made by the state legislature on a matter enumerated in the concurrent list of the 7th schedule is repugnant to a law made by Parliament, the state law will prevail only if and to the extent to which it has received the assent of the president. These three situations make it abundantly clear that while exercising the power to promulgate an ordinance, the governor is not liberated from the limitations to which the lawmaking power of the state legislature is subject. So, my lord, as a matter of fact, Article 213 aids my interpretation that despite there being contrary aid and advice, the governor has the room for discretion. So that's the respectful submission supported by, my lord, a 7-judge bench judgment, my lord. And I have, my lord, now given the contingencies for such reservation over and above the express clauses under the Constitution cannot be illustrated exhaustively, but may depend on the following factors. My lord, please pause here for a minute. My lord, I have cited in my initial respectful submissions and even during these submissions that there are judgments which says that irrespective of constitutional provisions, there are discretions available, calling the minister, calling someone to form the ministry, etc., etc. Lord, in none of those cases, in all those cases, the Supreme Court was very clear that these are only illustrative and not exhaustive. Because the Supreme Court was very clear in my submission that there may be circumstances which may arise in future where, other than the illustrations which we give, the governor may have to exercise his discretion. I'll come to that. But I have given, my lord, the broad parameters within which, my lord, he will have this discretion, where the bill is capable of subverting the Constitution. Nobody can dispute this, my lord. Where the bill is undermining the Constitution. Where the bill erodes the principles of democracy. Where the bill is of such a character that it has a national implication. My lord, therefore, my lord, I have given an example of Punjab water dispute. My lord, 4 states involved, Punjab, Haryana, Rajasthan, Delhi. There was an international treaty with Pakistan. And one assembly said that we revoke the agreement entered into. And, my lord, now we are faced with an argument that you have no option. Even a void bill, you will have to grant assent to.
This court granted stay of that.
Yes, obviously, my lord. But, my lord, that would not take away the power of the governor. My lord, I am kindly, my lord, appreciate. Your lordships are right. Your lordship stayed it. But that would not have taken away the power of the governor also to withhold. That you can't do this. This affects the federal structure. 4 states are affected. The center is affected because there is an international treaty in place.